The most interesting piece of information is this couple of sentences, because this is a completely different narrative to what Nexon would have you believe in their statement that they filed with the court. Hey, what's up, everybody? Onepeg here with my lovely assistant, Arnie. Here to provide you guys with an update to the Ironmace versus Nexon court case that is pending being held in Washington State in the United States of America regarding Digital Millennium Copyright Act infringement and violation of trade secrets, specifically the DTSA or Trade Secrets Act. For those of you looking for documentation specifically regarding this case, I've started a Patreon. If you want to check that out, you can find it here at patreon.com/real_onepeg, where I'm starting to upload the court filings, the cost of which is a mere $3. So $3 a month, you will get not only this, but also any research notes and stuff that I'm taking along the way. Any future cases or research projects that I'm working on for this YouTube channel will also be uploaded here, so you can see all of the background and have copies of the documentation for yourselves. Now, because all of these PDFs and whatnot are pretty much public domain, although I do end up paying 10 cents per page to get them from the U.S. Court's PACER system, $3 is a lot less expensive than the what appears, I believe, to be now $50 worth of documents that I have downloaded from PACER and provided you guys for the $3. If you guys copy them, they're public domain, post them on Reddit or whatever. I mean, by all means, you guys can do it as a Google drop, you know, but I'm just trying to recoup the cost as best I can. And these cases ends up being thousands, sometimes tens of thousands of pages. It can get really expensive. So if you feel like supporting me through that, that would be awesome, and I would really appreciate it. Anyway, in this latest round of court stuff, we have a couple of documents. One of them is a 264-page evidentiary document to support an order pending from the court to request that they are served. Terry and SDF get served with paperwork to appear in court, a court summons, via what is known as an alternative method. So this document here is a proposed order granting plaintiffs, Nexon, ex parte motion for alternative service of process under Federal Rule of Civil Procedure 4F3. The Federal Rule of Civil Procedure 4F describes the process that has to be followed in order to serve an individual in a foreign country. In this case, it would be both Terry Park and SDF. So there is an internationally agreed means of service that has already been pre-established way back in the early 1900s and then updated multiple iterations through till about 1965, which is the current convention that is being followed. There is an internationally agreed means of service that many countries, including the United States and Korea, have signed documents stating that they would follow this process and procedure, and by other means not prohibited by international agreement as the court orders. And through this document, what they're requesting is to Defendant Choi, otherwise known as SDF, that you can see here, SDF on Discord. So that is now confirmed, as well as Defendant Park, Terry Park. They're asking to provide that service to them either through Discord, through email, or through Twitter. Now, this hasn't been signed in as an order as of yet, but I expect that it will be. I think from what I've read, this seems like it's pretty standard practice and procedure. But the reason why they're doing that is right now there is a standard convention on the service abroad of judicial and extrajudicial documents in civil or commercial matters concluded 15 November 1965. So most recently, way back in the 60s, the HCCH, enter The Hague, by the way. Yes, that Hague, the one located in the Netherlands. The Hague, this building, the HCCH, is a international recognized disinterested third party, let's say, that offers a service to provide documentation for this means and other means to internationally recognized parties through this agreement that multiple companies had signed. The idea being that the United States, in this case, for the documentation that they would be serving to Korean nationals such as SDF and Terry, even though Terry has dual citizenship, SDF is a citizen of Korea, the summons would have to be sent through The Hague, translated, and then provided to SDF based on certified means through The Hague via US Post or otherwise, and that process can take a while. In the supporting documentation that these guys provide, that Nexon provides, they actually show copies of emails that were sent back and forth between Nexon's attorneys requesting this service. We're looking for the Western District of Washington. Could you provide an estimated timeline? And this is from Somin Lee from Arnold and Porter. And then Aaron Lukin, who's a member of Viking Advocates, who is a consulting firm that handles these type of things through Hague Service, says that it's going to anticipate proof of service in 4 or 5 months after submission of the requests. As soon as we have all documents in translations, a countersigned engagement letter, and fees, we won't need much time to get the shipment out. just a day or two. So they're trying to say they need to prep all this in advance. It would take them a couple of days, but the process by which that would actually be served to Terry and SDF would be 4 or 5 months. Now, Nexon, even though they want to drag their feet in court, most likely, and try to bleed Ironmace dry, doesn't want to have the court case pending for 4 and 5 months, because what they're going to try to do is, once this gets going, my guess would be that Nexon would try to file an injunction, a temporary injunction, to force Nexon to stop production of this game in order for them to conclude the court proceedings, because Nexon would claim or cite further potential damages. So that's basically what's happening. However, in the midst of this, there was an interesting piece of evidence that was added as supporting documentation, which is something that we haven't seen before. And this was a response letter that was provided to the council or to Nexon, the Nexon's attorneys, regarding a response to a cease and desist letter that Ironmace talked about having received in the past, but never showed us the letter that they got. Now, Nexon never provided us with that piece of documentation either. We don't actually have a copy of the cease and desist letter that was sent off. Now, remember, a cease and desist letter is just a threat that they're going to take somebody to court over something if they don't stop. Like, you better stop, otherwise I'm going to come for you, right? Like, that's the purpose of a cease and desist letter. It's not a cease and desist order. That is different. That goes through a court process, and then there's a cease and desist order from a judge telling somebody that they must stop or, you know, face penalty of the law, right? In this case, Nexon is saying, well, you're going to stop or we're going to take you to court. This letter is a response to that C&D, which, again, we don't have a copy of. However, there is a couple of pieces of interesting stuff here, which is an issue of contention, and I'll explain why. We, a law firm named Lynn, are sending this letter to Nexon Korea Corporation on behalf of our client, Ironmace. This letter serves as a response to the letter dated March 23rd, cease and desist, from Nexon, which demanded Ironmace to cease and desist the misappropriation of trade secrets and copyright infringement. The most interesting piece of this paragraph is this date, where they say that the letter being served as a response to the letter, the original cease and desist from March 23rd. On the 22nd of March, the day before, the DMCA request sent to Valve was actually sent off to Valve to their email account. So this letter that they're referencing was the day after they sent that first original letter for the DMCA takedown notice to Valve, which is kind of interesting. You would think that they would ask the studio, they would ask Ironmace to stop production prior to sending that off to DMCA takedown, which makes this a little bit interesting. You would think that the company would say, all right, we'll send the C&D off. We'll see if Ironmace actually listens to it. They probably won't, but we'll give them a couple of days and see what they're going to do. And then if they don't, then we'll do the takedown request. In this case, they just said, no, we're just going to shut it down. It doesn't necessarily mean much of anything, but I'm going to guess that that would be an argumentative point for the defense. Please note that if the CEO of Nexon instructed and participated in illegal activities, including business interference against Ironmace, the CEO will be held jointly liable for damages and be subject to civil and criminal penalties as a perpetrator. So what they're saying is that they can hold the CEO, or they're saying that they can hold the CEO personally liable for making this judgment call to go after Ironmace, because they say that Ironmace is the victim of bullying, basically. Now, whether or not they can actually go after him, I don't know. Maybe in Korean law, that's something that they're allowed to do because that person, the CEO, is the head of the ship, but I digress. In the cease and desist letter sent to Terrence, Nexon stated that they believe Dark and Darker is a counterfeit game that was created by stealing and misappropriating Nexon trade secrets, etc., etc., etc. Demanded cease and desist of development, testing, production, etc., etc. On March 22nd, Nexon filed a takedown notice to Valve with the content similar to the above. So there you go. This was one day before sending the cease and desist letter to Mr. Park and Mr. Choi. The filing notice resulted in the removal of Ironmace's Dark and Darker from Steam. Nexon's claim that Ironmace used their trade secrets and copyright materials while developing Dark and Darker is without reasonable grounds and is merely a unilateral and vague speculation by Nexon. Contrary to Nexon's claims, it is evident from the materials presented that their takedown notice was willfully filed for the sole purpose of interfering with Ironmace's business activities, despite their knowledge that there was no misappropriation of trade secrets and copyright infringement in Ironmace's development of Dark and Darker. Now, I think that that is obviously yet to be seen from Ironmace's standpoint. They're going to claim that it's bullying and, you know, it's just a bully tactic, et cetera, et cetera. I don't know if that's actually true. No one knows that that's actually true, right? Like, there's going to be bias on both sides. You have to remember that anything that Nexon says on their side is going to be as far embellished as they possibly can while being just on this side of legal. The same thing is going to be true for Ironmace. They're going to say everything that they possibly can just to this side of legal by using verbiage like it is to be believed that, or we believe that, etc., right? And under penalty of perjury. First, upon reviewing Nexon's claims of copyright infringement, we can confirm that Nexon had planned to file a takedown notice with the sole intention of interfering with Ironmace's business activities related to Dark and Darker. Although all of the works listed in Exhibit A of the cease and desist letter were completed around 2021, their copyrights were registered in February and March of 2023. In light of these circumstances, it's clear that during the development of the P3 game, Nexon did not initially believe that the works, visual arts, and movies AV works of the P3 game were worth protecting by copyright. However, they later registered the materials and copyrighted before filing a takedown notice to Steam with the intention of interfering with Ironmace's business activities. Furthermore, as discussing in detail below, the works listed in Exhibit A of the C&D or lack originality, so the copyright registrations for these works cannot be deemed valid. Now, this last section of the sentence, I think, is something that they could argue. This entire first section isn't really how that works. In the world of copyright, and it does look bad, I'll say that, filing the copyrights as late as they did don't look great, because a lot of times when corporations work on stuff like this, they will file copyright as progress and processes proceed. Now, there is a somewhat of a cost to that, but it is relatively minimal compared to IP if you believe it to be important. In most cases, companies will file copyright on this kind of stuff relatively early in the process. Nexon didn't do that. That doesn't mean it's not protectable, though, because the way that copyright works is copyright is protectable from the moment of inception. So, like if I created this YouTube video and somebody went and tried to make a copy of it just completely out of context and just took this as a carbon copy and just uploaded it on their own channel, I can still file a copyright claim on that, even though I haven't actually copywritten this video and any other video that I've made. The copyright still stands. It's still copyrightable. It just means that in order to go to court, you have to file specific pieces with the U.S. Copyright Office as a reputable source to pull that copywritten information from for the purpose of evidence. That's it. So this piece doesn't necessarily mean anything. But again, I digress. In Nexon's claim for misappropriation of their trade secrets, they suggest that Mr. Choi of Ironmace transferred more than 11,000 source code, art resources, and build files from 2020 to 2021. Now, we've seen all of this piece in stuff like that already. What we haven't seen is this next part. This was done with several written approvals from Nexon executives in compliance with Nexon's remote work policy in response to COVID-19 from 2020 to 2021. Now, we know that that is true. We have confirmed from both sides that they agree that there was written permission through at least early January of 2021. So for that entire time period up through till January of 21, you can't really claim that anything was being stolen because he had permission to be able to move files back and forth. Further, during the P3 project, Mr. Choi used an external server for efficient game development with Nexon's tacit approval. In other words, Nexon allowed Mr. Choi's use of external server for work purposes despite their knowledge of such usage, as they could monitor data transmission outside the company in real time. So what they're trying to say is, yes, he had a personal server and he was moving files back and forth, but at any time the security office or officers could have looked at the files that were being transferred back and forth and modified what he was and wasn't allowed to do at any point in time, but they didn't do it until such time was convenient to make it look bad. Mr. Choi announced his resignation from Nexon due to an uncertain corporate atmosphere. This atmosphere was caused by his superior's public announcement that he had no intention of supporting the P3 project, and a loss of trust between Mr. Choi and Nexon around June of 2021, which resulted in the cancellation of several projects. Now, this short couple of sentences is actually an awful lot of information, because there's a direct conflict of narrative here. The most interesting piece of information is this couple of sentences, because this is a completely different narrative to what Nexon would have you believe in their statement that they filed with the court. According to Nexon's statement, this number 1.pdf again that you can find on my Patreon, in their own statement, they say that SDF was hired in April of 2018. 2 or 3 days after he was hired, he signed a piece of documentation that said if he ever left service of Nexon, he was to delete any and all information about Nexon, their trade secrets, their files, whatever, off of any personal computing devices, mobile or otherwise, that he had in his possession. No questions asked. You are to delete them immediately. Now, according to this, Mr. Choi said that he was going to resign. According to this, Mr. Choi's announced resignation caused them to suddenly instruct their internal audit team to investigate Mr. Choi for leaking trade secrets, because again, they knew that he was using his personal servers to send information back and forth. Even if they had been unaware of any of the information that was being sent back and forth in 2021, which could, in essence, I'm not saying that this is necessarily true, but in essence, it could be argued that the reason why that was being used was due to service deadlines that had to be met in order to meet thresholds of standards so that the game could actually succeed and possibly move on to further developmental stages. It could be argued that he was doing that because of fear of or temporary COVID lockdown restrictions still having to meet those deadlines. 2021, most countries, ours included, was not out of the woods yet. There were lots of instances of people locking down for 2 weeks or a month at a time, depending on where you lived. So that isn't out of the question. However, Nexon, of course, is well within their legal right to be able to argue that that is stealing, and he didn't have permission to be able to do so. In this letter, they contest that he was doing so at the behest of Nexon, and that Nexon knew about it because they could have looked and seen him doing this on a daily basis anytime that they wanted to because of transfer logs. But again, that is for the courts to decide. But this announcement saying that he was going to resign, as opposed to Nexon's narrative of him being terminated, because in their own statement they say that they terminated him in late July, mid-July of 2021, is a completely different narrative to what we're seeing in this letter. And he's saying that it was done because his superior's public announcement that he had no intention of supporting the P3 project. Now, personally, I haven't seen a public announcement from Nexon in the span of history where he said, or they said at any point in time, that they weren't going to support P3. Perhaps he means a public announcement internally at Nexon. I'm not sure. But again, this is a different narrative to what Nexon says, because Nexon claims that the project was crippled. Following disciplinary proceedings, meaning firing Mr. Choi, Nexon terminated him for his egregious misconduct in July of 2021. And then they further go on to say, with most of the key P3 project team members gone, it was difficult for Nexon to continue the P3 project. Now, they never said that it was impossible to continue the P3 project, but they said it was difficult. So according to them, Mr. Choi and this personal investigation, and then Terry Park and 9 other developers leaving the team to go and work on this themselves, or just resigning for their own particular reasons, and then going and working with the folks at Ironmace on this game, was because P3 was destined to fail because the boss didn't want it to succeed. Even though Nexon says that they had no intention of doing so, and in their own statement they say that they believed that Project P3 was going to move into full production, that has no basis in reality as of right now. There's no proof of that. And Nexon, being the large corporation that it is, with access to, I would only assume, thousands of potential developers via payroll or otherwise, probably had the ability to be able to hire replacement developers and see the project through to fruition if they really wanted to. Again, if those files are copies, they had all the files, they had all of the historical logs, and they still had half the development team that knew what they were working on and what the game was supposed to look like. They may not have had a creative director, but they still could have been working in the same type of direction. Insofar as the destruction of these trade secrets, this says, as a result, Mr. Choi consulted with his lawyer and deleted all information from the external server to protect his privacy and Nexon's information. Now, again, this is based on an agreement that he signed on, I believe, April 16th of 2018, saying that he was going to destroy all evidence of any information related to Nexon, like the date of termination. He was supposed to remove all of those files. There is a piece referenced in the original document that was filed by Nexon saying that Mr. Choi signed a written forensic agreement with Nexon to turn over his servers, but quickly changed his mind and refused. The interesting thing about this statement here is that while this is alleged to be true, or believed to be true on Nexon's side, throughout the entire document, if there's a reference to a piece of documentation that was signed or files that were found, etc., all of this has a date and timestamp damn near. They have it right down to on July 12th, on July 21st, on this day, on that day. But this is the only thing that they talk about where there's a signature on a piece of paper that they don't actually have a date for. And I find that to be very interesting, because if this occurred at the date of termination or the day after termination, that could easily be argued away as like he either just wanted to get out of there and was like, yeah, whatever, or didn't know what he was signing, wasn't paying attention to it, and then realized after the fact, didn't get a copy of it, or it was after he was terminated, the day after, and they said, well, we want to see your servers. All right, fine, whatever. And then he like signed a piece of documentation and then said, no, I'm not going to do that, because he then consulted with his lawyer, and his lawyer told him, well, just destroy everything. You wouldn't want to leave yourself out there. What if they, do X, Y, and Z and say that it was malicious? I don't think that that's necessarily him being shady. It could just be him trying to protect himself because he had a really bad relationship with the people that were working with him. So I don't necessarily look at that as it could be something shady. I look at it more like it could just have been a situation where him and his boss were not getting along, and he just didn't trust that Nexon wasn't going to screw him over. I wouldn't want to necessarily give a former employer, in the past, we've all had bad bosses. I wouldn't necessarily want to give a former employer access to things where he could potentially damage me. This fact shows that the internal atmosphere was uncertain enough for Nexon to cancel the P3 project at the time. On the other hand, it clearly demonstrates how much trust Mr. Choi as a director had given his colleagues. Looking carefully at the objective facts of this case, it is clear that Nexon's claims of misappropriation of trade secrets and copyright infringement are only a pretext to interfere with Ironmace's business activities related to Dark and Darker. While they say that this fact shows, we don't know that this is actually fact. It shows the fact that they have 9 people leaving is true, but we don't know what their motivation for leaving is true. We know what Nexon's claim to their motivation is, and we also know what Ironmace's claim to their motivation is, but we're not sure what actually is true because none of these people have given any type of testimony. Lastly, in the case of the C&D, Nexon cites the similarities between Dark and Darker and the P3 game as the grounds of potential copyright infringement and misappropriation of trade secrets. And then it appears that the rest of this letter talks about the 2,338 files. What I do find to be interesting, though, is this last piece. The remaining 82 files with generic named files are subjected to the file naming convention commonly used in first-person fantasy games. When applying this convention, it is not unusual for around 0.182 of approximately 75,000 files to have identical file names. The file names of 950 assets and plugins and the 82 conventionally named files are attached in Exhibit A. And then they go on and they list a whole bunch of other stuff. So while this is something that makes sense on paper when it comes to this 0.182 files out of 75,000, that doesn't seem like it's that damning. Nexon's claim regarding trade secrets is how it's assembled, and that's really what's being argued in United States court when it comes to this kind of stuff. It's the assembly of the Legos off the shelf from Walmart. It's not necessarily the Legos being off the shelf from Walmart, if that makes sense. This clearly shows that despite being well aware of the details, Nexon as a large game company is intentionally focusing only the superficial aspects of these facts in a malicious manner. Then they go on to talk about core concept, genre, and storyline, which is not something that's copyrightable. And then the letter goes on to claim that Ironmace is being damaged by this. As you're fully aware, Ironmace had posted a test version of Dark and Darker on Steam from 2022 to 2023, received high expectations from users, ranking second among upcoming releases on Steam for the year 23, with approximately 2 million cumulative users and around 100,000 concurrent. However, Nexon's filing of takedown notice has made it difficult for Ironmace to release Dark and Darker through Steam. If Nexon had not filed a takedown notice, it's evident that Ironmace's Dark and Darker through the Steam release would have recorded greater sales than any game Nexon has released through US gaming platforms thus far. I completely agree with that. In fact, it might actually propel more game sales if they were to go into early access. I do believe that they would do 2 million units. I do, even at like a $30 price point. I genuinely believe that they would sell that much. Therefore, Ironmace demands that Nexon cease and desist from interfering with their lawful business activities, withdraw the takedown notice against Ironmace, which Nexon submitted to OSPs, including Steam, within 3 days of receipt of this letter to remove the ongoing interference, and cease and desist from interfering with Ironmace's lawful business activities through any other means. Now, we obviously know what happened as a result of this. Nexon has obviously, from the date of this C&D letter, or the counterclaim letter, or whatever you want to call it, Nexon obviously has not done any of that. They decided that they were going to persist with the DMCA takedown. They have obviously persisted with the court case here, and this has all been provided as supporting documentation to expedite the court process. So it looks as though what Nexon wants to do is get this thing to a trial. And they're trying to do it in a quick way. My guess is they would likely end up dragging this through court once it gets there. But right now, with the letters being sent and everything, they're trying to get summons in place so that Ironmace has to actually send reps to appear in court, virtually or otherwise. And it appears that they don't want to wait 4 to 5 months to do it. And that's what we have for this one. For those of you that want to see more news and information regarding games like Dark and Darker, survival and shooting games, etc., please consider subbing the channel. For those of you that want to see any and all documentation related to this, please consider going and supporting me on Patreon. That stuff really, really does matter. And for those of you that want to see me live, I stream every day around 7 to 8 a.m. Eastern Standard Time, most all days of the week. At twitch.tv/Onepeg, or every once in a great while, there's a secret stream at kick.com/Onepeg, which we started doing very recently. So in the meantime, I will see you guys in the next one. Thanks so much. Love you all. Peace.